Julian Genta.
Mr. Chair.
I rise to speak on part one of the bill, and I'd note that this part of the bill is the most problematic for the Green Party. This is what I raised during my second reading speech. While on the one hand, we support the changes that mean that student loan borrowers who are working overseas for approved charitable organizations in approved aid activities as volunteers are entitled to be treated as if they were physically present in New Zealand, and as such they're not charged interest on their student loans for a maximum of 2 years. And so we thought, yep, that makes sense. It's good that we're making it easier for borrowers who are working for charitable organizations to have that recognized so that they receive this benefit that they're entitled to of a holiday on an interest holiday, if you will. But overall, the Green Party has great concerns with the student loan scheme generally, and I suppose it goes to overall priorities about whether or not it's important to prioritize the opportunity for education for people without loading them up with a whole lot of debt. And for the Green Party, it would be a priority for us to ensure, in order to create a knowledge-based economy, a clean, green economy, all of that we're investing in our people and giving them opportunities. And we aren't really giving them opportunities when at the same time we're offering them an education but loading them up with debt. And so, but I would say that as many of my colleagues have referred to in part one of this bill, the changes to the student loan scheme that on the one hand, while we overall would question whether or not that should be a priority for the government to ensure that students are paying for their education as opposed to the wider society, which is going to benefit from that, that the principle of information sharing for the purposes of ensuring that, say, taxes are paid when they should be is really important. And so I can understand this principle of information sharing, and we thought it was a good thing in the bill that in that clause 26, there is this full disclosure of information to the Australian Tax Office, and a whole lot of information is provided so that people who have taken on student loans under the scheme, even though the Green Party doesn't fully agree with that scheme, they have taken on the loan, and we want to ensure that the borrower is paying it back. It might be 600 or 800 million that's owing in student loans. According to the regulatory impact statement, they estimated it was something in that order of 600 to 800 million of people living overseas who haven't been paying back their student loans. And so one of the ways that we resolve this is through information sharing and understanding exactly who the borrower is, what their name is, their date of birth, all this information. And that seems perfectly reasonable. But, you know, in the context of the amount that's owing, it's in the context of things, that amount that's owing is quite small relative to the amount that we might be missing out on tax not paid by multinationals, for example, who are avoiding paying tax in New Zealand. The amount that we're missing out on there, between 500 million to $1 billion, possibly more, is considerable. So we have the resources of the government being put to chasing down people with student loans, rather than focusing on much greater amounts of money that we're missing out on tax from multinational corporations who aren't paying their fair share here. And at the same time, we're going through this process to do this information sharing with Australia and to gather all this information about the borrowers. And yet, when it comes to foreign trusts in New Zealand, we don't request any of that information. So we don't make it possible for our partners, you know, in the world, other countries who are partners in double tax agreements, or even they can't request information about very, very wealthy people who might be using New Zealand foreign trusts to avoid paying tax in their home country. Virtually the only country that could request that sort of information is Australia, and that's only because they complained to the New Zealand government in 2006 because they knew that wealthy Australians were using New Zealand as a tax haven to avoid paying tax. And since we don't have that sort of agreement with other countries, they're not able to request this information. And strangely, you know, when we proposed in the House last week to the Prime Minister that it might be good to have a register with more information about the settlers of these trusts so that other countries could request information from us and ensure that New Zealand foreign trusts weren't being used to dodge tax, Mr. Chair.
Chris, 540.